What's going on, guys? Welcome back to the channel, to the butterfly monkey effect. Today will be a discussion on this specific court case. Actually, I'm going to read this. It's 26 pages, and this deals with a lady who was trying to get a passport and was denied on the basis of citizenship. Okay? And another issue that arose from it is the processes that the government wanted to her to perform to go get proof that there is no birth certificate on record and so forth. And of course, she denied to do all that and so forth. And this is the outcome. This is a great case to read. There's a couple misconceptions, in my opinion, that a couple of readers of the document are making. So I'm going to try to dispel that. And then also I will try to compare and contrast too with the situation that I'm in with passports, because my goal is to not furnish a social security number, and I'm going to compare it and contrast to this. So to begin, this is a district court for the District of Columbia. Abigail Carmichael Jordan versus Marco Rubio, the Secretary of State. And it hasn't been published in any book, so this is still at the appeal level, not this ain't even the Supreme Court. But it didn't need to, right? It didn't need to go up to the Supreme Court. So, memorandum opinion. Abigail Jordan has been trying to get a passport since 2019. The problem: a passport application requires either a birth certificate or a letter confirming that an applicant lacks one. And it is Jordan's sincerely held conviction that obtaining either form of documentation would endanger her religious scruples. Right? So this is the first paragraph. And it's about what? The birth certificate, right? The ability to confirm her citizenship. The predicament has left Jordan dismayed. She feels called to evangelicalize the world, but does not want to sully her other beliefs to do so. Seeking resolution, she sued the Department of State and the Secretary of State collectively, asking the court to declare she is a U.S. citizen and order the issuance of a passport. So in this statement right here that the judge is making, that she is stating or demanding that she is found a citizen of the United States. So there's no aspect of national and all this other stuff that people are talking about, right? So this is her asking the court to declare she is a U.S. citizen, right? The reasons will come clear. Jordan originally filed pro se, and the circumstances on the ground remained stagnant. But once the court approved Jordan's request for counsel, the department's whistling took on a different tune. So they literally, while she was filing it, they weren't trying to hear what she said, but the minute she got a lawyer, they changed up. State and federal officials suddenly cooperated to attain the proper documentation for Jordan in a manner that did not violate her religious beliefs. And the department represented that it stood ready to issue Jordan a passport, so long as she filled out yet another passport application and submitted yet another photograph. Just by what this judge is saying on the first page, you could see that he's siding with her. Like the way some of the words he's using is like he can't believe that the State Department brought this, and hasn't and violated this woman's rights. Now the department insists the case is moot. Not so. Jordan continues to suffer consequences from the department's years-long refusal to issue her a passport. So much is obvious. She still lacks a passport. The court thus delved into the merits of Jordan's claims and finds that she is entitled to summary judgment on them. As for Jordan's religious freedom claim, the department imposed a substantial burden on her religious exercise when it demanded she obtain documents through a process that violated her religious beliefs. Now, they said two things here, right? One, that on her merits and finds that she is entitled to summary judgment on them. And then two, her religious freedom claim. All right? Keep those in mind. But the department has not presented a compelling justification to require Jordan to go through such a process, nor has it demonstrated that the process was the least restrictive means of achieving its national security interest. So this right here, just think of it as, at least in regards to a compelling governmental interest. That's important. They need to have that to be able to infringe on one of your rights to some extent. Not to say take it, but to some extent. So on that score, the court will grant summary judgment to Jordan. More, Jordan merits summary judgment on her claim under 8 U.S.C. 1503. She has made an unrebutted prima facie case that she is a national of the United States, entitled to a passport. This adequate remedy moots her claims under APA and the Mandamus Act. See, she filed paperwork under this, but they're saying that there is remedy under this because she's a national of the United States under this specific statute, this code, right? So if we go and check out what it is, should it have it open? And this should cancel out anything that people be saying that she's a national, right? Well, she is, but not in the context that people are saying, right? So right here it says, if any person who is within the United States claims a right or privilege as a national of the United States and is denied such right or privilege by any department or independent agency thereof or official thereof upon the ground that he is not a national of the United States. So the context of the denial or whatever restriction is based on nationality. Okay? But since this is Title 8, specifically Chapter 12, we need to go to those definitions to understand what national of the United States means. Understand this. So Chapter 12, Section 1101, under definitions, it says specifically as used in this chapter. So we're in Chapter 12, and Section 1503 is in Section 12. We go down to number 22, because they're calling her a national of the United States under Section 1503. And we all should know that this has two definitions. National of the United States means a citizen, which is a term, right? Citizen of the United States is a term. Or B, a person who is not a citizen, but owes permanent allegiance to them. Right? This is a definition and not a term. So this applies to a class of persons. Now, if you believe this aspect is you, then so be it. But in regards to the court case, right? She is declaring and stating to them that she's a citizen of the United States under under that specific code, and not a non-citizen national as is defined under 1101.22. Hope you guys understand that, because that's gonna punch a couple people in the face. Hearing facts hurts people's feelings. All her life, Abigail Carmichael Jordan has avoided the perceived stain of a social security number. Her devout Christian faith teaches her that her God-given identity is sacred, and that the allegiance she owes to her government as a citizen of the United States and must be subordinate to her allegiance to her creator, right? God first. She thus rejects the possibility of being enumerated or marked by the government, such as by obtaining an SSN number, as to do so would be treating the government as if it were God. And she cites Revelations 13, chapter 13, verses 16 through 18. Her parents shared his belief. Indeed, her parents did everything in their power to ensure that she did not receive a birth certificate when she was born, including withholding her first name from hospital officials, for fear that applying for a birth certificate would result in the issuance of a number. So the thing to point out about this paragraph right here, right, is it's the rejection of the social security number. And in this case, they never asked her for the number. There's never the number never comes up. It's only the birth record that comes up, and the process of proving that there is no record of her is the only thing that's really at issue here. That actually does come up, right? But it's her fear on her religious belief side to not be enumerated, and she believes that getting a birth certificate would result in that in some way. Now, they don't admit that in this case. I kind of don't believe it does, right? It might create some type of a record, right? But it doesn't create the issuance of the number, right? Because now they don't even do it no more. They have to ask you completely, and you can say yes or no. It's not a mandatory thing to be created. Whether they create one behind the scenes, who knows? But, all I'm saying, it's a good thing what she's doing, right? But the difference between her and probably many of us is she never got one in the first place. For whatever her parents did or didn't do when she was younger, she didn't get one. That doesn't negate our argument. All I'm saying is the situation for her is a little bit different. Maybe that's probably why they couldn't attack her on getting a number. But that also tells you about the voluntariness of them needing to have one, right? They don't need to have a number for passport purposes. So that means for those who have one, right, there's always an out because it's voluntary. They have to have a specific national whatever governmental interest to mandate it. So understand that. At the same time, Jordan's faith calls her to make disciples of all nations. To carry out this mission, Jordan has been seeking a passport for 6 years. First, in 2019, Jordan applied for a passport and attached a sworn letter explaining that she lacked an SSN for religious reasons and that she did not have a birth certificate or fear that she could be assigned a number if she applied for one. To bolster her U.S. citizenship bona fides, meaning she has evidence that she's a citizen of the United States. In the absence of a birth certificate, Jordan attaches several records, including sworn declaration for her father and a certificate of childhood baptism and a childhood immunization records, among others. So among others there's more, all right? The department denied her this, right? And if you guys look in the regulation for passport, it's going to be 22 CFR 51. It'll be in part 51, right? And you'll find that if you don't have a birth certificate, okay, you could give these evidences, right? So just by what they just stated, that's enough. 100%, that's enough to prove citizenship, her nationality, right? Okay, well, we can only guess what those documents say. Declaration from her father, certificate of childhood baptism. Now, she is claiming citizenship of the United States. So, before and after the 14th Amendment, what was the only requirement to become a citizen? Birth in one of the states of the Union. Or naturalized, right? But I'm guessing birth here. So To each their own what they want to believe. All I'm saying is, if these documents are enough to prove her nationality, right, to bestow citizenship, right? Okay, well, what do you think they said here? This was not enough for the department. Most relevantly, the department stressed that Jordan failed to supply a statement from the appropriate state registrar of records certifying that there is no birth record on file. That is, the department needed a so-called no letter of record from Jordan to issue the passport without a birth certificate. A letter of no record is a documentary evidence that is necessary to confirm a first-time applicant's claim of non-existence of a U.S. birth record, which is essential in examining a purported citizenship claim of a first-time applicant. According to the department, the requirement that a passport applicant without a birth certificate obtain a letter of no record is critical in preventing not only identity theft and fraud, but is essential in upholding the integrity of a U.S. passport. One of the most common types of passport fraud includes using fake birth certificates or stolen identities when applying for passports. Now, what did they just state? They're stating their compelling public, purpose instead, their interest in it. The letter of no record is a safety precaution to ensure that someone who she says she is, aiming to comply, so she's trying, Jordan visited Virginia's Office of Vital Records to request a letter of no record. So, because they're talking about birth, right? And she was apparently, it seems to me, born in Virginia. So I'm going to guess that's what the affidavit of her father says, right? So we could discount naturalization. So now all we have to do is look up what are the principles of citizenship, right, that would constitute being recognized as a citizen of wherever she was born at. In this context, it's going to be Virginia. That's how you know what her citizenship is. Multi-use might say that, oh, she's wrong and she don't know what she's doing. Hey, you could say that all you want. But the office informed Jordan that she could not obtain one unless she filled out a form entitled Birth Certificate Information, which asked for her name at birth, date of birth, place of birth, hospital of birth, race, sex, and parents' names. Jordan was fearful that the submission of such information could be construed as request for a birth certificate, or could otherwise cause the office to create a stand-in record for her containing that same information, which could then be passed along to the Social Security Administration for issuance of a Social Security number. So she's denying to fill out that portion for them to go look up the record, right? Date of birth, place of birth, and information pertaining to her birth. I don't even know what information do you think that she could possibly give them to show that if there's a record for her. That's why the letter of no record is kind of retarded. Like, what could you possibly give them that they won't use against you, but it will be good enough for them to go do a search? Well, used against you in the context of what she's stating, right? Her fear of what might be created. So Jordan refused to fill out the form and did not receive a letter of no record. Her passport application was accordingly denied by the department. She appealed that denial but never received a response. Now, they're denying her based on birth, the birth record. But she's using for the fear of not wanting to get a Social Security number created, right? Why she didn't get an appeal should have been something that she argues, right? Because under Section 22 CFR 5170 through 74, right? They have an administrative process for denials of a birth certificate, like based on the information that's required, right? It doesn't say that she said that they went through it, right? But what it looks like is they're sending letters back and forth, and they're telling her they want this information. So for me, it looks like there was never an appeal to appeal it at the administrative level, but they do offer one. So I'm guessing because this restricts the right to travel. I'm not completely specific on that, right? But it doesn't have it. There is no administrative recourse for a hearing under those sections, right? 51.70 to 74 for denial based on no social security number. That means you got to take it straight to court. But for birth certificate reasoning, right? There is one, because it could be dealt with administratively to try to acquire one for that person or submit enough information that proves citizenship, because there's many different things that could be used, right? But not with the social security number. You can't go, they can't expect you to go there to one of their hearings and be like, okay, well, we need one from you. Because they can't do that. It's voluntary to go get. But a record of your birth is not like a voluntary thing. That has to be somewhere a record, even amongst your family, like a record amongst yourself of who you are and what you represent and all that stuff. I think so. 3 years later, again sought a passport. She explained to the department she could not obtain a letter of no record consistent with her religious beliefs. And she submitted more evidence of her U.S. citizenship, so gave her more information, right? But again, her application was denied because she had not submitted the letter. Jordan then brought this suit. She originally proceeded pro se. Upon Jordan's motion, the court appointed counsel and set a briefing schedule. So she finally got a lawyer, her own motion. Jordan amended complaints brings 9 counts against the department and several Virginia officials. Broadly, it argues the department and Virginia defendants infringed her right to religious freedom, right, which would be a First Amendment violation, which we know religious freedom is just one, right, and violated the Administrative Procedure Act and violated whatever. And it seeks various forms of relief, including a permanent injunction ordering the department to issue a passport to Ms. Jordan or to provide her with an appropriate religious accommodation. A declaration that Mrs. Jordan is a U.S. citizen and is entitled to a passport. And a writ of mandamus, right, which you already saw that they tossed them out because her remedy under 1503 was sufficient. Or will be sufficient. Administrative Procedure Act, you would think it would be a due process claim, right? They don't discuss it here. But for sure, there's religious freedom, First Amendment issues is what she has. While this suit was pending, Jordan contacted Virginia's Office of Vital Records to request a letter of no record again. The deputy director informed Jordan that the office would not issue a letter of no record because the office located a birth certificate on file with the name Baby Girl Carmichael. This tracked with her an Ancestry.com search that revealed a similar certificate, which the parties learned about during this litigation. So whoever did this search, Ancestry.com, right? Why is it coming up as a hyperlink? You see that? I'm going to click it. That's crazy. It's coming up as a hyperlink. But someone, it doesn't say who, right? But they learned it during this court process. I'm guessing maybe this authorized it. I didn't look this up, so I don't know. While it is unclear how this partial birth certificate was created, Jordan has her suspicions. When she was born, healthcare providers ignored her parents' pleas to avoid collecting DNA or any information from Jordan that could be transmitted to the SSA under the enumeration of birth program. The way newborns obtain SSNs. Healthcare providers dishonored that request when they removed Mrs. Jordan from her hospital room in the middle of the night and drew blood to record her DNA. These same providers also initially stated that Mrs. Jordan could not be taken home until her parents provided her name for birth records, but ultimately relented. Still, this sequence of events likely resulted in the creation of a partial birth record for Jordan, which she never knew existed until now. She doesn't debate this. She doesn't argue this. They do argue that this might be her, whatever, abstract that they created at that time. So that is, even though it's not like an official full, document, right? For circumstantial evidence to promote her U.S. citizenship, right? All this did was help her case that she is a U.S. citizen. Meanwhile, the department and Virginia defendants cooperated behind the scenes. In February 25, they broke major news to Jordan and the court. The Virginia Office of Vital Records decided to forward the letter of no record to the department, obviating the need for Jordan to fill out any offending form. Jordan then voluntarily dismissed her claims against Virginia defendants with prejudice, not voluntary dismissal. As the deadline for Jordan's summary judgment motion loomed, the department informed Jordan that the letter of no record satisfied the documentary requirements for a passport. So it told Jordan that it would issue her passport if she submitted a new application and current photograph. It also agreed to expedite her passport application and assign her a person of contract to facilitate the process. So this is her basically trying to renegotiate. This is them trying to renegotiate with her, because they're saying, look at what they're saying. As the deadline for Jordan's summary judgment motion loomed, right? It's like 30 days, normally maybe 60 days. But Jordan remains unsatisfied. She has refused these offers, urging that there is no sound reason why she should have to fill out another application to receive her passport. She also fears that this situation could repeat itself upon the inevitable passport renewal in a decade. More, she notes that the department could revoke her passport at any time and require her to submit a new letter. She sought to judicially enforce consent decree from the department offering to terminate the litigation if the department signed on, but the department rebuffed that request. So they didn't even want to put something in her record. And this is what I'm going to end up doing too, to enforce them to put something in the record so in 10 years they're not demanding something that's not required in the first place to get a new passport, which, of course, like I said, is the Social Security number. See, like I said, she's using, think about the context, right? For those that never got a number and those who have gotten a number, right? Because of their parents or whatever. She's using religious context, fear of being numbered, right? Well, technically, that's true for any religion that I would have, no doubt, right? My family's Catholic. My wife is Catholic. Her uncle is the ex-Cardinal of Mexico. He was Cardinal of Mexico for like 27 years or something. right? So we're religious in all ways, but I feel I don't have to use that, right? Meaning my private life is my private life, right? And this is a public document. Well, that means that since it's voluntary, I should not be compelled to use it in the first place. That I don't have to use religion as the reason, even though I know I have one, right? But this right here, the voluntary nature of the system, is what I'm trying to shake out of these people. So they have to have a public, public interest in whatever they're trying to do in that statute for them to restrict your shit. So if you know anything about the passport laws and the powers of Congress in that regard, right? Well, it's only been in a national context. So this judge says it here too. If a suit is not a case or controversy under Article 3, the court lacks jurisdiction to hear it. So when the party moves to dismiss for lack of case or controversy, such as by claiming the dispute is moot, the court evaluates the claim under Federal Rules of Civil Procedure 12b-1. Now, why is this coming up here in this court case? Because the State Department is trying to get out of going to summary judgment. So they're trying to get her to agree into something else, and we're going to give you everything you need. So that would make the case moot. But she's not agreeing to that. Plus, there's other considerations that are involved, right? But they're trying to get it dismissed and recontract with her through another way so that there's no ruling on this specific issue because they don't want that type of ruling. But no doubt, understand that you got to show some type of birth record of your nationality. So whatever that may be, right? All I'm saying is understand what's voluntary and what's not. So while the court will accept factual allegations in the complaint as true, those allegations will bear closer scrutiny in resolving a 12b-1 motion than resolving a 12b-6 motion for failure to state a claim. And the court may consider materials outside the pleadings in deciding whether a grant of motion to dismiss for lack of jurisdiction. While usually it is up to the plaintiff to show that the court has jurisdiction, it is up to the defendant to establish that a once live case has been turned moot. While usually it is up to a plaintiff to show that the court has jurisdiction, it is on the defendant to establish that a once live case has turned moot. This is a formidable burden. A party is entitled to summary judgment if it shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Federal Rules of Civil Procedure 56-8. At the summary judgment stage, the court must examine the facts in the record and all reasonable inferences derived therefrom in a light most favorable to the non-moving party. So they're giving you the rules here too. This mode of analysis serves to separate the jury functions of making credibility determinations, weighing the evidence, and drawing legitimate inferences from the district court's role as the arbiter of legal questions. When parties file cross motions for summary judgment, each motion is viewed separately in the light most favorable to the non-moving party, with the court determining for each side whether the Rule 56 standard has been met. The court begins as it must with jurisdiction, and it concludes that the department has failed to satisfy its burden of showing mootness. The court thus proceeds to Jordan's substantive claims and concludes that Jordan is entitled to summary judgment. So basically everything we just read was all the factual statements or whatever, the argument. A case turns moot and thus falls outside the auspices of Article 3. When the issue presented are no longer live or the parties lack a legally cognizable interest in the outcome. In other words, the mootness inquiry asks whether events subsequent to the filing of the complaint have so transpired that the decision will neither presently affect the parties' rights nor have more than speculative chance of affecting them in the future. The defendant bears the heavy burden of showing that a live controversy has expired. Still, there is a wrinkle in this general rule. If the controversy's expiration stems from the defendant's voluntary cessation of allegedly illegal conduct, the tribunal is not deprived of power to hear and determine the case. In other words, the defendant cannot moot out a case by shaping up once it gets sued, right? Meaning, because they wanted to comply now. They wanted to give her a passport, right? Now, because they're about to fucking lose, they want to try to get out of it now. No. Otherwise, it's not like in criminal copping out, right? I don't know. In the civil aspect, I guess, right? You ain't no copping out like that if the other party doesn't want to. So, otherwise, the defendant could go back to its old shenanigans once the court got out of the way. This is known as a voluntary cessation exception to mootness. When a defendant argues a case is moot because it has willingly stopped the challenged conduct, the defendant must make two or more showings to prevail. First, it must show that there is no reasonable expectation that the alleged violation will recur. And second, it must show that interim relief or events have completely and irrevocably eradicated the effects of the alleged violation. The department has not satisfied this arduous burden. To begin with, the court affirms that this case is best understood under the voluntary cessation framework. The department argued to the contrary that the motions hearing, contending that it is not the department which voluntarily ceased unlawful conduct, but rather the State Office of Vital Records. That was the issue between plaintiff and Virginia. That wasn't a situation that could be controlled by the Department of State, meaning it's not their fault that she couldn't get a record of no letter. Now, with the letter in hand, it is prepared to issue Jordan a passport. According to the department, it is the state office that suspended the requirement that George provide personally identifiable information in order to obtain the letter of no record. By ultimately giving that letter to the department of its own volition, thus any doctrine that contemplates the department seizing challenged conduct, the argument proceeds, is inapt here. So understand one thing, right? Like, they're trying to say, well, the Department of Virginia sent it to you guys, right? You alleviated her burden of filling out that paperwork, right? But they're also saying, well, we might have wanted the paperwork from you, but we're not the ones who were stopping you guys from receiving that paperwork. Your complaint should have been on the Department of Virginia Vital Records to get that document, right? So, now in my opinion, they might have an argument there, right? But the question is the letter of record solely compelling? Like, is it totally required only? That's the true question. Was it necessary in the first place? They're trying to make it as if it's the issue at hand, and it's not. The court sees things differently. Before this lawsuit was filed and counsel was appointed, the department was adamant that Jordan herself supply the letter. Once counsel started clamoring, the department shifted course in initiating efforts to independently obtain the letter from Virginia's Office of Vital Records. After the filing of the amended complaint, and in an effort to resolve this matter, undersigned counsel certifies to the court that he worked with the Virginia defendants to obtain the letter of no record. Jordan's contemporaneous efforts failed. Her counsel wrote to, meaning her new efforts, right? Her counsel wrote to Virginia's officials explaining Jordan's religious objections and requesting that the office conduct a search of its records, and upon confirming that no birth record exists for Mrs. Jordan, provide her with a statement of no record of birth. Jordan's counsel stressed that he would pursue appropriate legal action if the letter were not provided within a reasonable time. The office responded weeks later by telephone informing Jordan's counsel that it was declining to issue the letter because the office had located a certificate with the name Baby Girl Carmichael. It then stated that it could not provide Mrs. Jordan with documentation of any kind unless she applied to amend the existing partial birth record and add her name first to the certificate. Though Jordan's own attempts stalled, the department prevailed. The office forwarded the letter directly to the department, which then shared it with Jordan and her counsel. I think they sent the letter to her first. I'm guessing that's her counsel saying that. Thus, the department suspended a practice which Jordan objected to, the requirement that she obtain supply a letter of no record. This makes the voluntary succession doctrine a clean fit, and the department has not met its burden to overcome the voluntary cessation exception to mootness. It starts off well. The department has satisfactorily shown that it is absolutely clear that the allegedly wrongful behavior could not reasonably be expected to reoccur. So I'm guessing just by their word, right, they're saying, okay, we're not going to screw with her in the future, right? For whatever they were able to satisfy this judge, they're not going to do it in the future. That's one, right? The department's counsel has represented that the department will keep the letter of no record in Jordan's file, so her passport will not be revoked or ineligible for renewal based on the absence of the letter or birth certificate. The court credits this assertion. It is settled practice fully to accept representations such as these when determining whether official conduct will reoccur. Relying on government counsel's representations in court when assessing voluntary cessation exception. More, only a first-time passport applicant must supply either a birth certificate or letter of no record. So even if the department were to eliminate the letter of Jordan's file and go back on its word, Jordan would still be eligible for a renewal. So, but put differently, there is no basis to conclude that Jordan will ever have to obtain a letter of no record or a birth certificate again. But they're saying that she would still be eligible, right? Like even if they were to eliminate the record on file, right? But the thing that I don't like, right, is that they're stating this. Where'd it go? That moreover, only a first-time passport applicant must supply either a birth certificate or letter of no record. That's not necessarily true, right? Because there's affidavits, right, by witnesses and birth records in Bibles and stuff like that. There's other records that could be brought forward. The birth record is probably more appropriate, right, than a birth certificate. Maybe they're stating in recourse to her specifically, right? Jordan's arguments to the contrary sound in conjecture. She insists that the department could revoke her passport at any time and demand she provide a new letter or a birth certificate. But I'm guessing if that's, I'm saying that's the judge or something, because someone is stating this. See, pleadings reply. I don't know what these citations are. I don't think it is a stretch. So whatever that response is. But such speculative contingencies do not show that challenged conduct is likely to reoccur in the absence of evidence that this is a prospect of immediacy and reality. stressing that plaintiff's speculative fears were wholly inadequate basis to find reasonable chance of reoccurrence. That's the court case that they're using against her. Against that challenge. In other words, the department has met its burden to show that there is no reasonable expectation that the alleged violation will recur. Jordan may not rebut this showing with mere speculation. Plaintiffs could not overcome government's mootness showing where the record contained no evidence that plaintiffs' fears of reoccurrence would materialize. The department has met its burden on the first element of voluntary cessation test, but it falters on the second. Jordan continues to face consequences from the denials of her passport applications. While the department represents that it stands ready to issue Jordan a passport, it refused to do so unless Jordan submits an updated application with new photograph. This extra hurdles constitutes effects of alleged violation, right? So resubmitting the application, right? The DS-11 form, right? These extra hurdles constitute effects of the alleged violation, and they give you a court case. Had the department dispensed with the letter of no record requirement and acknowledged Jordan's copious evidence of citizenship off the bat, she would have that passport now. And she would not be forced to exert more time, energy, and money to obtain a passport that all agree is rightfully hers. So basically, right, even though she's stating this is, just more work, right? The judge is stating the same thing. And it's something simple. You know as well as I do, it's something simple. It's about the DS-11 form. But the judge is like, fuck that, for what? There's already copious evidence and all that, like, that she already owns, supposed to have that's rightfully hers. The department may think that there are nothing more than a de minimis administrative burdens. That's, something under like $50 or something, $250. Arguing that this case, not a sound use of counsel's or any court's time. I'm guessing those are his comments, right? Some of these are his comments. Arguing that this case is not a sound use of counsel or the court's time. The idea that the department should have to forego other policies does not preclude the case as being moot. But it does not point to any case law that establishes a threshold for when ongoing harms count and when they do not. Further delays and obligations surely suffice. Indeed, in a related vein, the Supreme Court has acknowledged that a plaintiff's request for nominal damages can keep an otherwise moot case alive. So keep that in mind. This is what he's stating, right? Like, if you file a suit and you're doing, like, you're requesting like financial damages or something, it keeps the door open to their arguments on mootness. With the specifics, I don't know why, right? But like, he's saying more than just get the simple remedy. You're looking for more. And okay, now you wasted my time, court fees and whatever the fuck else and shit, right? Instead of just getting the passport. I got to read the case to understand that, right? And they're using this one. This reflects that even seemingly small forms of relief are concrete and effectuate a partial remedy. Thus, the possibility of their issuance can provide redress to a plaintiff. Similarly, in the standing context, courts have roundly recognized that the amount of economic harm is irrelevant to the standing inquiry, as a dollar of economic harm is still an injury in fact for standing purposes. And they give you another court case. The department has not shown that the court why it should depart from these precedents, collective wisdom that so-called minor harms, which still invite judicial relief, keep a suit in the land of cases and controversies. Here, Jordan faces ongoing harms. The department is making her expend more labor because she can obtain a passport. Before she can obtain a passport, she have received 6 years ago. She should have received 6 years ago. Plaintiffs' concrete drain on their time and resources constitute injury in fact. Those injuries can be avoided if the court intervenes. Since an aspect of Jordan's injury persists that can be relieved by an appropriate court order, this case is not moot. The court therefore turns to the merits of Jordan's claims. Begin with Jordan's allegations under the Religious Freedom Restoration Act. This statute provides that the government shall not substantially burden a person's exercise of religion unless it demonstrates that application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. And this is what you need to be looking for. Unless it demonstrates a compelling governmental interest. And they be giving you a citation, 42 USC 2000 BB-1. This is something you're always looking for. Don't be like, oh, they're in my house, they're in my pocket. Man, they're in the house either because you let them in or they have a right to because of some contract, some reason, some, or another. Some constitution, some act, I don't know. Even neutral, generally applicable laws are susceptible to the challenge under the RFRA. Whether the department has violated RFRA thus boils down into two phases. First, the court asks whether the challenged conduct substantially burdened the plaintiff's religious exercise. If so, strict scrutiny applies. For that stage, the court probes whether the imposition of the burden was in pursuit of a compelling government interest. So for that specific stage right there, right? They scrutinize, right? And probe whether the imposition, the statute itself, right? The requirement in the statute for you to do something of the burden was in pursuit of a compelling government interest. So remember, we're dealing with passports, right? So the denial of a passport based on what? On not providing a no letter, right? When she has multiple evidence of her citizenship. So no matter what, she is by law able to get one. Even a social security number, right? Outside of a specific government interest, right? They don't have a reason to even ask you for the number. Section 2714AF, right? Out of Title 22, that is just the authority to deny it. But they're still restricted by the Constitution. They still have to have what? A compelling government interest. So in my case, with no social security number, there's only one code that asks you for the number. That's 26 USC 6039E. And with that, you have to have a foreign residency for tax purposes. That's it. I don't qualify that. They have to show how I qualify for that. But them just denying you and stating 2714AF means nothing, because they're just using a raw authority or raw power without no restrictions or even in my case no due process, because there is no administrative hearing for denials of social security number. I know how I'm going to write on my paperwork, but understand that difference. And it queries whether the pursuit of that interest required imposing a challenge is the challenge burden. This is a stringent and excessively demanding test. Only if the answer to both strict scrutiny questions is yes, can the department justify its behavior, meaning denial of the number of the passport. Start with the substantial burden question. Jordan asserts that the department imposed a substantial burden on her religious exercise by saddling her with a dilemma: defy her religious convictions or forego a passport. Jordan is correct. The department denied Jordan's passport application because she did not submit a birth certificate or a letter of no record. And they give a whole bunch of administrative little citations. Jordan's religious convictions, however, prevent her from obtaining a birth certificate. Due to the unacceptable risk that an SSN will be generated for an individual with birth certificate information on file in Virginia, even when an SSN is not specifically requested. And they also bar her from acquiring a letter of no record, as its application leads Jordan to fear that it could be construed as an application for a birth certificate containing that information, or would cause the Office of Vital Records to generate some other stand-in record containing all the same information that could then be transmitted to SSA for the issuance of a SSN. In short, the department withheld a coveted, meaning people really want one, right? Withheld a coveted public benefit unless Jordan abandoned the teachings of her faith. Such carrot dangling is the classic example of a substantial burden on religious exercise. The rule is black and white. A person may not be forced to choose between following the precepts of her religion and forfeiting benefits on one hand, and abandoning one of the precepts of her religion on the other hand. And they give you a good court case for that, 1981. Which, for you guys, for sure to read them. I will eventually, but since my argument is not religious, but still, my argument is similar to this. They cannot deny me a benefit just for refusing to furnish a number, which I'm not required to by law. I swear, that's literally what it is right there. And the Privacy Act literally bars them from doing that. So, do I have a suit? Absolutely, I know I have a suit. But here, that is precisely what Jordan was asked to do. Passport or salvation. Thus, she had made to suffer a substantial burden on her religious exercise. The department's counter-arguments failed to persuade. First, the department argues that this case is controlled by Supreme Court opinion in Bowen versus Roy, 1986. And derivatively, the D.C. Circuit opinion in Kamerling versus Knappen, 2008. It is not. Begin with Roy. There, a father objected to the state's use of his daughter's SSN when doling out welfare benefits. The Supreme Court held that this gripe could not support a free exercise challenge. Roy objected to the statutory requirements that state agencies shall utilize Social Security numbers, not because it places any restriction on what he may believe or what he may do, but because the use of the number may harm his daughter's spirit. That was his argument in that court case. He has to bring an injury to you, a burden, to do some act that violates your faith. But the court stressed that the free exercise clause cannot be understood to require the government to conduct its own internal affairs in ways that comport with the religious beliefs of particular citizens. Roy put no more prevail on his religious objection to the government's use of the Social Security number for his daughter than he could on a sincere religious objection to the size or color of the government's filing cabinets. Now, he's making fun here because all he's saying in that court case, which prosecutor is trying to use on Jordan, is that you can't tell us what we can do with the number, right? You could object to giving us the number, right? But you can't object to what we're going to do with it. Like, we have our own purposes for it. So he's equating that to trying to tell us for changing the color of our filing cabinets. There's a good income tax case where there's one like that too, where it's based on trust stuff too. So he's telling the trustees that, like, there's so much fucking ways we could smack you upside your head because you have a sham trust and stuff that it's hilarious. Like, I don't know. It's just crazy. Because Roy did not object to the forced alteration of his own behavior, and that's what you're looking for. A statute that forces an alteration of your behavior that comports, right? But comports to your religious views, but offered a theological critique of the government's behavior. See this? The difference in his argument? He could not state a free exercise claim. This is important to understand here. That said, 5 justices explained that Roy could not be compelled to provide an SSN on his family's welfare application. Michael W. McConnell, Free Exercise Revisionism, and the Smith decision. Oh man, let's search this right now. See if we can find that right now. This is worth looking it up. It's right here. Okay, at least I got it now. Okay. Not that. Let me read that again. That said, 5 justices explained that Roy could not be compelled to provide an SSN on his family's welfare application. And he says Blackburn, O'Connell, they joined in Justice Brennan and Marshall concurring in part and dissenting in part. This did not become a holding of the court because one of the 5 justices believed the question was moot. Still, a majority of the court saw a clear distinction between a claim based on coerced personal conduct and a claim based on the government internal procedures. This right here, though, I gotta read this. The reason why is this, okay. A welfare application, right? What is that? A government benefit or a privilege, right? Provided by law? Well, that's what the passport is too. But this welfare application has nothing to do with the fundamental rights that the federal government protects. The passport has dealings with and affects your right to travel. That's the only 2 main differences between the 2. So if they're saying he's not compelled to provide the number for welfare, then no doubt for the other privilege of a passport, you're not required to either. So in my opinion, reading this little thing would be a good little note side thing for what I'm arguing. Still, a majority of the court saw a clear distinction between the claim on coerced personal conduct. Remember, that's what you're looking for. Coerced personal conduct and a claim based on the government's internal procedures. While Roy's claim fell on the latter side of this gulf, Jordan's is squarely on the former. She protests a mandate on her individual behavior, the requirement that she apply for a birth certificate or letter of no record and spur the risk of being branded by the government. Unlike Roy, she is not objecting to the government's internal use of the SSN that has already been created. She has qualms about her own participation and complicity in the potential issuance of a number. How would this hurt me right here? Unlike Roy, she is not objecting to the internal use. Well, shit, neither am I. I'm objecting to their requirement. They haven't shown me a requirement, and there's only one, and I don't qualify. The same conclusion goes for the department's reliance in Camerling. There, a convicted felon objected to the state's practice of collecting fluid or tissue samples from qualifying offenders to create a law enforcement DNA base. Camerling argued that the collection and retention of his DNA information is tantamount to laying the foundation for the rise of the Antichrist, which defied his strongly held religious beliefs about the proper use of the building blocks of life. Following Roy, the D.C. Circuit held that Camerling did not allege sufficient facts sufficient to state a substantial burden on his religious exercise because he cannot identify any exercise which is the subject of the burden to which he objects. Camerling did not object to the Bureau of Prisons collecting any bodily specimen that contained DNA material. Instead, he objected to the government's extracting DNA information from that specimen. The circuit stressed that the extraction and storage of DNA information are entirely activities of the FBI in which Camerling plays no role and which can occur after the BOP has taken his fluid or tissue sample, to which he does not object. Thus, like the father in Roy, Camerling's opposition to government collection and storage of his DNA profile does not contend to any act of the government pressures him to change his behavior and violate his religion, but only seeks to require the government itself to conduct its affairs in conformance with his religion. This type of theological critique did not constitute a substantial burden. But what he's saying here, though, like, this is an argument for employment also. The governmental pressures him to change his behavior. The behavior would be the use of the number. Like I said, some of the major cases for employment purposes that are using religious exemptions or whatever for the no number, they didn't defend them right? They allowed them to let their religion, their faith be scrutinized. Meaning that, oh no, you're not really that faithful to think like that since you don't do these other things that are part of your faith. That type of shit. Again, Jordan's claims are not simply proselytization. Jordan insists that the department has put substantial pressure on her to modify her behavior and to violate her beliefs by forcing her to apply for a birth certificate or letter. Thus, Roy and Camerling do not dictate dismissal here. Instead, the dichotomy they set up bolsters Jordan's allegations. Second, the department pokes holes in the reasonableness in Jordan's beliefs. It stresses that Jordan's parents could have obtained a birth certificate for her without risking the assignment of an SSN, as the SSA enumeration at birth program is voluntary. And that's the whole thing, right? They always made it seem like it was never voluntary. They just, here, fill this out, you can get this number and all that shit, right? But it has been. So, like, that's why people like myself and like Yusavel and stuff, right? Well, basically, I got it from, or learned it from. It's commercial, man. It has nothing to do with your citizenship. It has everything to do with that entity that you're walking around with. That's it, man. And it points out that adults face virtually no risk of unwittingly receiving an SSN, as there is no enumeration program for adults whereby an SSN is issued when they request a birth certificate. The department traces the path an adult would have to take to obtain an SSN, which includes filling out an application for a Social Security card, forwarding it with required documentation to Social Security Administration for review, and potentially undergoing a personal review. Thus, according to the department, Jordan's fears are unfounded. The court is disinclined to bicker about the ways the system works. It very well may be that Jordan never faced a substantial risk of receiving an unwanted SSN at birth or during adulthood. But for Jordan's RFRA claim, the actual risk is irrelevant. What matters is whether Jordan sincerely believes that applying for a letter of no record conflicted with her faith because it exposed her to the unacceptable possibility that she would be stained with an SSN. And this is what matters. This is right here your belief, your fear. And here there is no dispute that Jordan honestly believes this. So the court must credit her fears. It may not tell Jordan that she is mistaken about her dictates of her own faith. And that's what they've done in those other court cases for employment. A letter concerning toleration, 1689. So this is John Locke. So they're going all the way to the year 1687 on a book by John Locke. They give you a quote here. The care of souls cannot belong to the civil magistrate, because his power consists only in outward force, but true and saving religion consists in the inward persuasion of the mind. Memorial and Remonstrance against Religious Assessments. 2 writings of James Madison. The religion, then, of every man must be left to conviction and conscience of every man. The opinions of men, depending only on the evidence contemplated by their own minds, cannot follow the dictates of other men. Nor may the court draw a line on the near occasion of sin. And that's Reverend Francis J. Connell, 1949. I'm guessing this is the G. Hunt edition for the Madison reading, 1901. Shit, I might be having I'm going to buy some of these. This conclusion is compelled by the Supreme Court decision in Burwell v. Hobby Lobby in 2014. There, the proprietors of closely held corporations objected to a federal policy that required them to provide health insurance to their employees that covered methods of birth control that could destroy an embryo. Now, remember, this is proprietors of a closely held corporation, so that is the type of entity, right? Objected to federal policy. These birth control methods conflicted with the proprietors' beliefs that life begins at conception. The Supreme Court held that the federal law imposed a substantial burden on these plaintiffs. If the proprietors did not yield to a demand that forced them to engage in conduct that seriously violated their religious beliefs, they faced severe financial penalties. Such an intolerable choice, according to the court, was a substantial burden on religious exercise. In holding so, the court rebuffed arguments that the connection between what the objective parties must do, provide coverage of potentially abortive fashion contraceptives, and the end that they find to be morally wrong, destruction of human life, was simply too attenuated to constitute a substantial burden. Such an argument, according to the court, dodged the question of what RFRA represents, which is whether a government policy imposes a substantial burden on the ability of individuals to act in accordance with their religious beliefs. Instead, the argument addressed a very different question that the federal courts have no business addressing: whether the religious belief asserted in the RFRA case is reasonable. The proprietors sincerely believe that providing the insurance coverage demanded by the federal regulations lay on the forbidden side of the line. between prescribed and proscribed conduct. That was all that mattered. It was not for the court to say that their religious beliefs were mistaken or insubstantial. That's huge. So that's the Hobby Lobby case, right? That you guys should be reading right here. Hobby Lobby controls here. Just as the religious proprietors feared their participation in the issuance of the could lead to, oh man, I already read this. No, sorry. The issuance program could lead to their facilitation of abortive activity. Jordan fears that providing birth certificate information to the government may catalyze the issuance of a SSN, and asking to be branded contravenes Jordan's faith. The honesty of this conviction cannot be doubted. Jordan herself was given a partial birth certificate without her knowledge or consent. After hospital staff collected Jordan's DNA without her parents' removal. Here's what's crazy about this case. This judge did not have to go through this RFRA standard, right? The reason why is because she won on the merits under 1503 of Title 22. She gave copious evidence to the court that deemed her eligible as a right to get a passport. Like the furtherance of getting any paperwork, right, to even talk about the RFRA never even had to come up. This right here is on purpose. This is the judge doing it on purpose. The honesty of this conviction cannot be doubted. Jordan herself was given a partial birth certificate without her knowledge or consent after the hospital staff collected Jordan's DNA without her parents' approval. And one of her family members was issued an SSN against his will. They don't give specifics on that, at least not here. This is going to be Jordan whatever, paragraph 10, right? Thus, it is understandable that Jordan sees the passport application process as a string of dominoes, unless she's referring that she filled out that no letter requirement, that she filled out that paperwork and they gave her as a SSN or something. I don't know. And it is undeniable that Jordan views filling out the paperwork as flickering the first domino in the line. That is all the court evaluating RFRA claim can assess. Her fear of that first domino with that initial information on the purpose of what that form is for. And that's all they need to access on that type of a claim. The department suggests that Jordan's case is different from Hobby Lobby. According to it, in Hobby Lobby, the proponents of the contraceptive mandate were attacking how the proprietors interpreted the tenets of their own faith. But here, the department does not doubt that Jordan's faith compels her to avoid the issuance of a SSN. Rather, the department only seeks to disprove the secular and factual belief that Jordan faced a risk of receiving an SSN. I don't think there's any realistic concern. But to deem a belief secular rather than religious is to beg the question. After all, we are judges, not moral philosophers or theologians. This is not a question of legal causation, but a religious faith. And he quotes a case, University of Notre Dame versus Sebulus, and this is a 2014 case too. Granted judgment, certiorari granted, judgment vacated. I don't know what subnom means. Faith implicates difficult and important questions of religious and moral philosophy that necessarily involve individualistic calculations of tolerable levels of risk and complicity. Sure, those calculations will be factual understandings as inputs, but an adherent's ultimate assessment of the risk and thus her ultimate perceived degree of culpability is the output, and that necessarily involves faith-based value judgments. The mandate infringes plaintiffs' religious liberties by requiring them to lend what their religious teaches to be an impermissible degree of assistance to the commission of what their religion teaches to be a moral wrong. In other words, an adherent's understanding of the spiritual consequences of an action and her own concomitant blameworthiness. What's this word here? The meaning of concomitant is accompanying, especially in a subordinate or incidental way. And her own concomitant blameworthiness is deeply personal and part of her faith itself. It is not the role of the court to correct that understanding by trying to prove her wrong. Even if Jordan is misguided in thinking that the scheme is spiritually risky, that is not the court's call to make under the first prong or RFRA. Kavanaugh dissenting. Under this court case, right there, he's quoting a court case. Dissenting from the denial of rehearing en banc. That is, Jordan's legal interpretation of what triggers the issuance of an SSN is beside the point. What matters is whether her participation in the scheme, however minimal, violates her religious beliefs. And the record offers no dispute about that fact. That's huge. That's huge on all arguments. This is page 20 and 21. That's huge. I don't know if you guys understand how huge that is. Jordan sincerely believed that acquiring a birth certificate or applying a letter of no record will violate her religious beliefs. That is where the inquiry stops. Because Jordan was put to a choice between violating her religious beliefs and receiving a passport, she was made to suffer a substantial burden on her religious exercise. That brings the court to strict scrutiny. The department satisfies strict scrutiny only if it demonstrates that application of the burden to Jordan is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. Put differently, so long as the government can achieve its interest in a manner that does not burden religion, it must do so. That is a difficult hill to climb, and it was never meant to be anything less. And man, these court cases right here. The department does not surmount it. To begin with, the department has not shown that it has a compelling interest in requiring Jordan to supply a birth certificate or a letter of no record. It insists that the letter of no record is necessary to confirm the non-existence of a birth record and is essential in examining the purported citizenship of a first-time applicant and is critical in preventing not only identity theft and fraud, but is essential in upholding the integrity of the U.S. passport. So that's their compelling interest that they're trying to argue. But as critical as these generalized interests may be, the department cannot rely on them to satisfy its burden. And they give you another court case right here. The court must look beyond the department's broadly formulated interest and instead scrutinize whether the department has a compelling interest in requiring the particular claimant to satisfy the documentary requirements. Whether the department has a compelling interest in forcing her to fill out that document. And I'll give you another court case here. The department does not even mention Jordan while making its compelling interest arguments instead invoking abstract notions of national security untethered from this dispute. So they're fucked. The department counters this argument that it is not at liberty to determine that certain documents are not needed for some individuals like Jordan while requesting them from others to issue a passport. But that is precisely what RFRA requires of the department. 42 USB 2000 BB1 requiring the government to show that the application of the burden to a person furthers a compelling interest. Requires the government to show that the application, not a form, right? This means the thing done. The application of the burden to the person furthers the compelling interest. Stressing RFRA's focused inquiry on the asserted harm of granting specific exemptions to particular regions' religious claimants. More, the federal law regulating passport issuance explicitly recognizes that passports cannot be conditioned on First Amendment activity. A passport may not be denied, issuance, revoked, restricted, or otherwise limited because of any speech protected by the First Amendment to the Constitution of the United States. 22 U.S.C. 2721. Ooh, almost spilled my drink. Kinda did. Nothing bad. Let's go look at what this is. Impermissible basis for denial passport. A passport may not be denied issuance, revoked, restricted, or otherwise limited because of any speech, activity, belief, affiliation, or membership within or without the United States, which, if held or conducted within the United States, would be protected by the First Amendment of the Constitution. And you know what? This probably came out after the 1960s with the communism and all that stuff, because that's what a lot of those documents and a lot of these regulations came out at. The department must accommodate when it is necessary, but the department has not even argued how eliminating the letter of no record requirement for Jordan, and only Jordan would determine its interest in passport integrity. Perhaps this is because the department could not make such arguments if it tried. Jordan has provided abundant, independent evidence of her citizenship. It is unclear what the letter of no record from Jordan, a document that the department admits is not directly probative of citizenship, could add to the passport adjudication. And that's, I swear, that's all he needed in the beginning. He did not have to go through that religious stuff. I swear to you right now, this judge right here is a truth teller. He chose to give us that information because she gave enough information that did not even have to require her to go fill out some paperwork or anything. No one suggests Jordan poses a risk to national security or is engaging in criminal conduct. Thus, the letter appears superfluous, just some extra crap that they're demanding, right? It may be a rote administrative requirement to the department, but it carries the threat of inquiry for Jordan. I don't know what this word means. See if it is a word. And nothing. The meaning of rote is used of memory usually with little intelligence. Rote is a noun that means learning something by repetition rather than by understanding it. Repetition, administrative requirement, but it carries the threat of iniquity for Jordan. And that's literally what they do. They like just put it there and then give you that feel of force of government like it's supposed to be required from you. That's like what I'm interpreting this. It's just something that they just have done for so long, and fuck them sometimes. More, the history of these proceedings revealed that requiring Jordan to obtain a letter of no record was not the least restrictive means of carrying out the department's generalized interest. After some cajoling, the Virginia defendants forked the letter over to the department without involvement from Jordan. Indeed, Virginia law envisions this circumstance by allowing state officials to provide this information directly to federal government. Clearly then, the department did not lack other means of achieving its desired goals. While the department insists that it had no obligation to seek the letter on behalf of Jordan, may in some circumstances require the government to expand additional funds and efforts to accommodate citizens' religious beliefs. The department could have worked with the Virginia defendants from the beginning, thereby eliminating the need for Jordan to pay a spiritual toll. That's crazy. Like, I mean, technically, right, what are they? They're supposed to aid you anyway. They're public servants. They're supposed to be to help you. Well, my religious convictions don't allow me to do this, and you're the one that's looking for this document. Okay, well, go get it. You know what I'm saying? Like, this should be one of the duties that you have for me as a public servant. When a potential compromise like this exists, the department cannot show it pursued the minimally onerous path. The short of it is the department imposed a substantial burden on Jordan, and it failed to show that the burden was the least restrictive way of achieving the compelling interest. Jordan is entitled to summary judgment on her RFRA claim. With the RFRA claim resolved, the court proceeds to Jordan's claim under Title 8, 1503. This provision authorizes any person denied a right or privilege by any department or agency or official thereof upon the ground that she is not a national of the United States to institute an action in the federal district courts for a judgment declaring her a national of the United States. This category of rights and privileges includes a passport. To prevail under 1503A, Jordan needs only make a prima facie case establishing her citizenship by birth or naturalization, at which point the birth shifts on the government to present clear, unequivocal, and convincing evidence rebutting the plaintiff's showing of citizenship. Well, that's the point of it, right? I guess this would show, right, filing under this, or making this part of, say, my paperwork, right? What would this do? This one would show that I have a right to a passport, right? Establish that as a citizen, I have the ability, the right to travel and everything. But it still comes down to that number, so I don't know. I don't like the idea of putting that in there, but the way they say it right here, it doesn't hurt or really add anything either. Just basically proves that you're this. Jordan is entitled to relief on her 1503 claim. But here's the thing too, right? That's literally what the question it asks, right? You're making a claim that you are a national of the United States. The national of the United States means two different things. The only way one of them will be determined is by the documentation that you have that confirms either one or the other. That's it. That's literally what this would do for the purposes of like getting a passport and so forth. Jordan is entitled to relief under her 1503A claim. The department concedes that Jordan is a U.S. citizen, and Jordan has proffered a body of evidence establishing that much. I wonder if they will concede after the fact, right, or early on. Thus, Jordan is entitled to the issuance of a passport, and the court will order the department to provide Jordan with a passport right away. See, this is what I want, right? This is what I would write though. If I were to use this 1503A claim, right, then I would write something like this, that I am entitled to the issuance of a passport. You know what I'm saying? To that extent. I have established my body of evidence establishing my citizenship and blah, blah, blah. It's just an added thing. I look at it more as an added thing. Because unlike her, I wasn't denied based on citizenship. Let me read these annotations. Jordan concedes that a favorable judgment on her RFRA claims eliminates the need for the court to opine on her First Amendment claim, which is fucked up, which is probably what she really wanted. If you rule on an RFRA, it does not need to get into the free exercise claim. The court treats that cessation concession as a voluntary dismissal, given it has favorably disposed of the RFRA claim. And that's what I don't want. I wouldn't want this. Jordan's success on her 1503 claim extinguishes her APA claim, conceding that full relief on the 1503 claim obviates her APA claims. Only APA claims for which there is no other adequate remedy in court are subject to judicial review. And hers did, right? Because she was being denied based on the citizenship part, right? So 1503, there was another adequate remedy for her. Now, for my case, Social Security numbers, there is no administrative remedy, and I haven't found another statute that says, no, I could go here. I could use this one based on that. So until I find that, that don't mean nothing. More, Jordan has not moved for summary judgment on her Mandamus Act claim, which is count 7. But seeing as Mandamus also requires a plaintiff to show her she has no adequate alternate remedy. And that's the thing. Man, that's crazy right there. No adequate alternate remedy, because I don't have another one except court. My claims are going to be under the APA. Shit, I'm going to look into this Mandamus one. And relief under the 1503 extinguishes the Mandamus claim anyway. They give you a Illinois case in 2023. Court listener. This is oral arguments. I don't know. Maybe I'll listen to that later. Got one more page. I know I put you guys to sleep. Thus, Jordan is entitled to an issuance of a passport, and the court will order the department to provide Jordan with a passport right away. A final note on remedy is in order. The court will provide Jordan with the injunctive relief she requests, an order directing the department to issue Mrs. Jordan a passport forthwith. The traditional scope of injunctive relief is the extent necessary to protect the interest of the parties. Any injunction should be limited in the inadequacy that produced the injury in fact that the plaintiff has established, and no more burdensome to the defendant than necessary to provide complete relief to the parties. Jordan's harm stems from the department's persistent refusals to issue her a passport, in violation of her rights under RFRA and Section 1503. Absent such violations, Jordan would now have her passport in hand without the need to shoulder additional administrative burdens and costs. Thus, an injunction directing the department to issue the passport is necessary to remediate Jordan's injuries. Such relief is not unduly burdensome to the department. The most recent photograph and home address of Jordan provided is only 2 years old. The typical lapse between passport application is 10 years. So The judge is using this excuse for her not to have to fill out more information that you already have her picture and her application and her address and all that stuff, and it's only 2 years old. So the department is not made to suffer unwarranted harm by issuing a passport without mandating Jordan jump through additional hoops that Jordan likely perceives as endlessly proliferating. It is time that the court releases Jordan from this bureaucratic funhouse. The Constitution does not contemplate that judges be spiritual arbiters. If someone sincerely believes she risks her salvation by taking some action, the government may not condition a benefit on her doing so. To find otherwise would be to arrogate an abhorrent authority. The court will not oblige Jordan to follow an agency's assessment of her personal convictions. She is entitled to summary judgment and a passport. And that's it. Now, if any of you want to go look up the case specifically, right, go on Court Listener or Pacer or whatever you use to try to look something up. It's on use. But this is on the government website as is. But man, this court case was impactful on multiple levels. But to clarify the final understanding of what it is, she is claiming national of the United States. The documentary evidence is that she was born in Virginia. That makes her, under the context of 1503, a citizen of the United States. Her rejection was all based on not giving more information on her birth, which I swear this judge gave us so many facts, so many gems, right? It's like almost unheard of in nowadays court cases. He gave us massive amount of gems on how he didn't have to go through that RFRA stuff. She won her stuff in 1503 just to get a passport. But at the same time, what did the judge say up here? What did they say? That if you rule on RFRA, it does not need to get into the free exercise claim. Maybe that too, he allowed that to happen too. And for me, I think the First Amendment claim needs to go forth. But to each their own. I hope you guys enjoyed. Make a comment, ask questions, and so forth. Until next time, enjoy. Have a good one.